Good afternoon, everybody, and welcome to the afternoon session of the Med-Tech conference. This session, there are two speakers. The first of those, we have Philip Cupitt, who's a patent attorney, and Sam Collins, who's a trademark attorney. They're going to be talking to you a little bit about developing a coherent IP strategy and how best to add value to your company with IP. They said they're going to do a little bit of an introduction and sort of tell you a little bit more about themselves and their organisation. So I'll leave it there and welcome Philip and Sam to the stage.
Good afternoon, thank you very much. My name is Philip Cupitt. I am a patent attorney and a partner in a firm called Marks Clerk. We're a national firm of patent attorneys and trademark attorneys, and what we do is we help our clients to use intellectual property to protect their investment in developing new products and services. So what we're going to talk to you about today is how to use intellectual property rights to protect your investment in developing new products and services for the healthcare industry. So firstly, what is intellectual property or IP? Well, one definition is that IP is something that you create possibly without trying to create it, but inevitably you will create it as you go through the process of innovation and developing new products and services, putting them on the market, continually improving them, selling them to your customers, and so on. Intellectual property is the byproduct of that. And intellectual property rights are legal tools that you can use to try to lock in the value of your investment in creating these new products and services. So to try to bring this topic to life a little bit, we have an example of a product. So this is an automatic external defibrillator device. So the sort of thing where if you have atrial fibrillation, these things will electric shock your heart back into life. Now, one of these devices is absolutely packed with different sorts of intellectual property which can be protected through different sorts of legal rights. So just considering the sorts of IP that are in this product, we have at the top left trademarks. These are a very common form of intellectual property. You see them in your daily life. So, for example, the trademarks covering this defibrillator are firstly the name of the product itself, which is CardioLife, but also the logo of the manufacturer, which is that square thing at the top left. So that's the first sort of intellectual property right that exists in this product, and Sam's going to tell you about trademarks in a bit more detail later on. Another form of intellectual property right that exists is what is called designs. So in the bottom left you can see what the manufacturers of this product have filed at a patent office to try to protect the appearance of their product. The idea being that once they've protected the appearance of their product, their competitors are not allowed to come along and produce look-alike products. If the competitors do try to produce a product that looks just like it, they have a right to sue their competitor in the courts and get that product taken off the market. Another form of intellectual property right is patents. Now, patents protect technical innovation. So I'm going to talk about that in a bit more detail later on, so I'll just park that for now. Another form of intellectual property right is copyright. So this is something that comes into existence automatically whenever you write something or draw something. So you are creating as a business so many copyright works all the time. Every time you write something, create a design drawing, publish something on your website, make a product manual, you're creating copyright all the time. And the final sort of IP is something that's not necessarily recognized very often, but confidential information or trade secrets. These are the things that you develop as a business to help you make a better product. It's your know-how in how to make that product. And this is something which typically, it gives you an edge in the marketplace, but you keep it quiet so that your competitors don't know how to make a product as good as you. It's like the secret recipe for Coca-Cola or KFC, and that's another very valuable part of a business's intellectual property. So, I've told you what IP is, but why should you be interested in protecting it? Well, there are a number of reasons why it is in your business's best interest to do so. So, firstly, having intellectual property rights creates a barrier to entry against competitors. It's what Warren Buffett calls creating a moat. By having these intellectual property rights, it makes it harder for your competitors to enter the market and to produce competing products and services. And this, in turn, helps to lock in the value to your business, so it makes you more attractive to potential investors. They know that they can invest in your business, safe in the knowledge that someone can't come along and copy you and erode your market share. IP rights are in themselves valuable rights. They can be traded, admittedly it's not an open market, but they can be traded on the marketplace. Some very valuable IP rights are worth millions of pounds. So these are concrete assets that have a definite value. So when you seek to protect the IP that you're developing, that gives you an asset that you can add to the balance sheet of your company. IP rights themselves can generate revenue, so you can license your IP rights to companies in other jurisdictions or companies you'd like to collaborate with, and in exchange for that they can give you a recurring revenue. So having some protection for your IP does give you access to a new source of revenue. Another advantage is that you can pay less tax. So there is a scheme called the Patent Box, which if you have a patent covering a particular product or service, the corporation tax on the revenue or the profits that you derive from selling the patented product can be reduced from the headline rate of 25% down to 10%. So it actually makes sound financial sense in some cases to have a patent. The whole patent process can be essentially self-financing through tax breaks. So those are some, to my mind, good reasons why you might want to protect your intellectual property. So let's now have a look at some of the main types of intellectual property right that are relevant to medtech businesses. So firstly, patents. This is my field of expertise. Patents are a legal right that protects or prevents other people from using a particular invention that you have protected by a patent. This is a source of a lot of confusion for people. A lot of people think that if you have a patent, that gives you the right to go and launch a particular product onto the market. Now, unfortunately, that's not how the patent system works, and it's not what it's intended to do. A patent is there to prevent other people from copying your invention. Now, patents are a very strong form of intellectual property right. If you have a patent, you can prevent your competitors from selling, making, importing, or using an invention that is covered by the patent. And you can do that for a period of up to 20 years. So hopefully that will give you plenty of time to market your product, establish a place in the market, make it profitable, and really get yourself established in the market before others can come along and start competing with you. The downside to patents is that they're expensive. You have to, or you'd be well advised to seek advice from a patent attorney such as me, and we charge for our services. So to obtain a patent, you could be looking at upwards of £10,000 per country in exchange for getting this very strong right to prevent others copying your ideas. So the sort of things that you can patent are products. So if you've created a medical device, you can protect that. You can also protect the processes for manufacturing that device. You can also protect software. So there is a very widespread misconception in the UK that software is not something that can be patented. Now, that's not true. If you come up with a new algorithm, for example, to control a medical device, that is potentially patentable. If you even come up with a new AI-based algorithm, for example, to control a medical device or to do automated diagnosis of a medical condition, that could potentially be covered by a patent, giving you 20 years of exclusivity in the marketplace. But not every technical innovation that you as a company make is worthy of patenting, or indeed something that you want to patent. Many companies need to make a decision between, do we patent this, knowing that's going to be costly, and knowing that patenting it will tell people how our technology works, or do we keep it a secret? Both, to my mind, are equally valid things to do as a business. You just have to assess which is right for a particular company, which is right for a particular product. But the benefits of keeping your innovation a secret are, firstly, you don't have to pay for it, whereas a patent lasts for 20 years, your trade secret can potentially last forever, provided you keep it a secret. Now, that is the risk of a trade secret. As shown by that picture, once the cat gets out of the bag, there's no way of putting it back. You can't stop something becoming a secret once the world knows about it. So you have to make a decision. Is this something that you want to invest in patenting, or is this something that you need to keep a secret? And to keep it a secret, really what you're looking at there is robust contracts with everyone you deal with as a business, so your employees, your suppliers, people you jointly develop with. You need robust cybersecurity and good policies in place to control how your confidential information is used and shared with others. So those are the two technical forms of IP. So now I will hand over to Sam, who is going to explain trademarks to you.
Thank you very much. Just as a brief introduction, I'm Sam Collins. I'm a trademark attorney at Marks Clerk. I've been doing it for about 13 years now, and I deal with clients of all different sizes and in lots of different sectors, including medtech. So what is a trademark? So a trademark is effectively a badge of origin. It's a sign that you use that differentiates your goods and services from those of your competitors. And what this means is that if a third party were to use your mark or something very similar for an inferior product, you have a strong right that you can rely on to do something about it. Unlike patents that have a shelf life, trademarks are effectively perpetual. As long as you renew them every 10 years and no one challenges them, they'll just keep going. So what can be a trademark? There are lots of different things that you can register as a trademark, from the very simple plain word mark like Osler Diagnostics. It could be a logo like the CMR surgical one. It could be your word element but with a figurative element too, like Nike and the swoosh. or it could be one of the more unusual types of trademarks, like the bottom right corner, that is a needle that Stryker Corporation have registered as a trademark. It could be a sound. I don't know if any of you are good at musical notation, but that is the direct line telephone jingle that someone has registered. And also, this is a smell mark, which is probably one of the most unusual types of trademarks. So when you are choosing, say, a product name and looking at a word mark protection, there is a scale. What you ideally want to avoid is a trademark that is descriptive or non-distinctive, as these will not be registrable as a word mark. Lots of businesses these days like to go for the suggestive route, so there'll be something in the mark that suggests a quality of the product, but the aim is to not have something that is wholly descriptive. At the end of the day, you want this to be something that your consumers look at and know it's your product. You don't want to pick something that is descriptive or well known in your field and that other people are going to actively be using to describe what they're doing. As a trademark attorney, my favourite marks are the ones that are completely made up, like your Kodaks and your Exxons, because they have no meaning. They're relatively straightforward to register as long as no third party has got there first. And not to exclude arbitrary marks, whereas, say, Apple would be entirely descriptive for apples, for computers, it's not. It's a distinctive mark and can be registered. So how are trademark rights acquired? Registration is the main way of acquiring them. In some countries, use can be enough to give you a level of trademark protection. For example, in the UK and other common law countries, you can get a degree of protection without a registration. But as a warning there, in some countries, if you have no registration, you have no rights, and that can make it very, very challenging if you're entering a new market and you discover that someone has registered your trademark there for your goods and services before you've got the chance. So these are the ways that you can acquire trademarks, and just to dispel some common myths, incorporating a company and registering a domain name does not give you a right that you can rely on in isolation to take action against a third party. Whereas if you have a trademark registration, that you can rely on to take action against a competitor who's registered your mark as a domain name, for example, or a company that's calling themselves something very similar to your trademark. So when you're looking at filing your trademark, these are the things you want to consider first. What are you going to register? It's an obvious question, really. Is it going to be, say, a main brand name? Is it a product name that you need to protect? Could it be a logo? Do you want to look at whether you can protect the shape of your product or the packaging for your product as a trademark? Secondly, what goods and services to cover? When you file a trademark application, you file it in relation to the particular goods and services of interest to you. So what you want to try and do in looking at your goods and services is think, what am I doing now? And making sure you have coverage for that. But also thinking, what are my plans for the next 3 to 5 years? How can I future-proof this? If you can incorporate all of that in your application straight away, then it means you're not looking at having to file another application in 3 to 5 years' time. And thirdly, where to register. Trademark rights are territorial rights, which means you have to seek protection in each territory of interest. This doesn't necessarily mean each country. There is an EU-wide trademark application, and there are other systems elsewhere in the world as well. But really, when thinking about where you're going to register, you want to look at where you're currently operating, where you're manufacturing, whether there are any high-risk countries, so countries where then it's known that counterfeit goods are coming from those countries. You might want to look at putting trademark protection in there to help in any customs actions, and also consider new markets that you're about to enter into. And when looking at this in particular, the next pre-filing consideration is, are there any existing third-party rights? Conducting trademark searches before you're in too deep is really important. The last thing you want to do is to have spent lots of money on product packaging and marketing only to discover that a third party has already registered your mark in relation to the same or very similar goods, and you have to go and rebrand. It's a very expensive exercise. So if you can conduct searches early in the process, you can at the very least go in with your eyes open, or you can consider rebranding before you're too far into the process. Searching can also be useful to see what your competitors are doing. And finally, on the trademark section, why are trademarks particularly relevant for medtech? So we're seeing an increase in the amount of medtech work in the UK, and this is leading to an increase in competition. And so trademarks can be a really useful way of helping you differentiate what you're doing from what your competitors are doing. Also, we're seeing in the NHS that they're increasingly giving patients more choice in their treatments. And patients, our end consumers, they are used to choosing products based on strong brands or the brand reputation. So ensuring that you have a strong brand that they can latch onto is really important. And the final point, I know I mentioned it before, but counterfeit medical products are on the rise worldwide. From about 2019, so before the pandemic hit, we started seeing an increase in counterfeit medical products, and trademarks are a key tool in the toolkit for fighting against counterfeit goods. You can register your trademarks with customs, and it helps customs and trading standards to stop what could be potentially really dangerous products from entering the market. So, thank you. Over to you, Philip. Stand next to you.
So to wrap up then, we're going to briefly explain how you as a company in the medtech sector can develop your own IP strategy to protect your products and services against competition. So just as a warning, first of all, IP is very complicated. We can't explain everything about it right now. So if you're in any doubt about what to do, you should seek an expert advice rather than make a mess of it yourself. So we're going to divide this into two phases. Firstly, what do you need to think about before launching a product? And secondly, what do you need to do after launching a product? So before launching a product, firstly, you need to identify the technical innovations that you as a business have developed over the course of creating that product. For each of them, you need to decide how you're going to protect it. Are you going to try to patent it? Is it something that you're going to actively keep as a trade secret? Alternatively, you might do nothing. You might just decide that actually this has no value, we're not going to patent it, nor are we going to go to the trouble of keeping it a secret.
And also, before launch, you want to think at an early stage about what are you actually going to call any products that you're developing.
It's important to take a look at others' IP rights before you launch a product onto the market. The worst thing that could happen is that you have spent tens of thousands, maybe even millions of pounds developing a product. You successfully go through all the regulatory hurdles, you launch it onto the market, and then find that one of your competitors has a patent that prevents you from selling the product yourself. So what we would advise is, before you get too deep in the product development process, search for your competitors' patent rights, and if necessary, change the design of your product so that you're not infringing their patents.
And also at this point, look to conduct a level of trademark searches before you invest any significant resources. As a good starting point, come up with a short list of maybe your top 5 names that you would happily call this product, and run some basic knockout searches on those so you can clear out any that are clearly a no-go at an early stage. And then once you are happy with your choice, then is the time to look at filing trademark applications for any core marks in your key territories of interest.
So once you have launched your product onto the market, assuming it's successful, it's generating revenue, maybe even generating a profit, then what you need to do is to keep up the process of identifying innovations. Products don't stand still. Typically, once one product is launched, you'll be looking to make your next product, you'll be looking to improve upon your product. So keep identifying inventions and deciding how you're going to protect them. Are you going to keep them as trade secrets, or are you going to patent them? I'd also say you should regularly evaluate your IP, so police the marketplace, make sure that your competitors are not infringing upon your registered IP rights. Also, reevaluate your IP rights regularly. So, for example, if you have a patent and you find that actually the technology hasn't taken off as well as you'd hoped it might, then maybe abandon the patent so that you're not spending money every year to keep that patent in force.
And also, you want to regularly review your trademark portfolio and your strategy for this, and check, does your current trademark protection match what you're actually doing? If you have extended the range of goods that you are using a trademark for, you need to check whether your existing protection matches that, and if it doesn't, look to bolster that protection. Also, have a regular review. Are there any new product names that we need to be looking at protecting? Are we entering any new markets in the coming year or so that we should be looking at least doing the clearance searching at this stage? And are there any new logos or any other things in the upcoming future of the business that you need to start looking at protection for now? And I think that was it. Thank you for your time. If anyone's got any questions, do come and talk to us afterwards, because I think we're... Oh, 1 minute. Any questions? No? Okay. Oh.
Yes, gentleman over there.
License purposes. Need to use a attorney for that.
What is a community patent type thing, which is different from the standard with legal people? Because my patent ran out after 20 years, and they said I can renew it again by using a community method. Any idea?
That sounds like a pretty complicated and niche thing that maybe we should talk about offline, if that's all right.
So, thank you very much, Philip and Sam, for a very clear overview of the IP and trademarking and some considerations for Med-Tech